May I have your lordship leave to mention a matter? Your lordship, we have
automatic judgment and September or July.
May I have your lordship leave to mention a matter? Your lordship, we are filing an appeal for the Section 9 order that was passed in the City Civil Court. Your lordship, a receiver is already appointed in that order. Your lordship, we are filing this appeal to challenge to the order. And your lordship, may I have a leave to file this appeal without the certified copy of the orders?
When was the order passed, madam?
1/9/2025.
Granted.
Much obliged, your
Just
lordship.
wanted to not wish my lord a very happy puja and happy Diwali, my lord.
And to you
I will
too.
not trouble your lordship, lord, today.
Please don't. Please ask your friends also not to. Thank you.
Is here. Just for time. Apologize, I was not there on the last day. But I get a feeling that it's being that an impression is being given to your lordship that I'm running away from the matter. It's not that.
I did not say anything.
But I get that feeling. That is what my attorney is saying. Well, on that day, on Wednesday, the matter was Tuesday, we were washed out. Wednesday, there was a part heard matter before a coordinate bench, which was part heard prior and was appearing as item number 1. And that bench gave precedence to that matter because there was an order of the Supreme Court saying that this has to be heard. And it was a continuing part heard matter, my lord. It was item number 1 before a coordinate bench. And I'll just show, and that on that day,
We will come to this case.
yes, please, my lord. Now, my lord, there's an order of about 3 months ago in June. This order, impugned order, was made. I would want to put in an affidavit, my lord, to bring on record certain subsequent events. If your lordships are considering an ad interim order today on the
Experty.
beg your pardon?
Experty.
This was no, my lord. An ad interim order was earlier made on a Section 9 application.
Disposal of Section 9.
An ad interim order was made on contest in a Section 9 application, wherein my bank accounts, to the extent of rupees 40 crores, I was restrained from operating. Thereafter, I took out a vacating application, and on contest, after hearing the parties, an order was made in the month of June vacating the injunction restraining me from operating my bank accounts and holding that the security which is provided in terms of the loan agreement, so-called loan agreement, because I do not say or admit that this is a loan agreement, is adequate security. This order was made in the month of June. This on 18th of June. This appeal has been preferred after the witness action in the reference has concluded. And the order by which the injunction was vacated, the order before your lordship, the impugned order, it's not that they are without security. There is adequate security. The learned judge was satisfied that the security which is standing is adequate security, and there is no cause shown to injunct me from restraining my bank accounts. That would in fact be bringing a running business to its knees. And liberty was given to the petitioner to approach the learned tribunal if they sought further protection. The learned tribunal, the arbitral tribunal, was constituted sometime in the month of May. The pleadings are complete. The witness action is complete. In over 4 months or 5 months' time, no steps have been taken before the tribunal seeking further security. And the final hearing in the matter is in the month of November. ये किसका है? बेटा तुम्हारा?
नहीं, आपका ही होगा. I do only ये talk about it.
Now, in these 3 months of the interregnum, there have been substantial developments in the matter. There's 9 volumes of papers are there. Kindly permit me to use an affidavit.
Let him file an affidavit, Mr. Ghosh.
The order has to be sustained on the basis of what was there. So that filing an affidavit.
He says there are subsequent events.
Yes.
Order.
Maybe relevant.
Yesterday we were in litigation before the Company Law Tribunal. I'm sorry, the National Company Law Tribunal.
Millard appreciates. It's Millard an appeal. Millard, either the order is sustained on the lower court papers or not, because it's not an ad interim ex parte order, Millard, which Millard has been not been granted, modified or vacated. It's an appeal, Millard, under section 37, disposing of Millard is section 9.
We'll hear the appeal on the reopening day. We'll hear the appeal.
The Lordship has already heard. Lordship has already heard me.
Yes, but
My argument is complete. My learned friend did not say on that date, Millard.
there are certain observations of the judge which are obviously incorrect, Mr. Thakkar.
I follow, my lord. I have some,
Lordship will set aside those.
Yes.
but that is
my final hearing will get affected by this, because the learned judge says
that your lordship will clarify that this is
Millard,
and
not
that
interrupt my learned friend at all. One sentence. Learned judge says, Millard, because of Millard approval of the plan of Millard SREI, ACFL and SIFL, SREI Equipment Finance and Infrastructure, my claim, whether my claim will survive or not, that's an issue to be decided by the arbitrator. Now, Millard, a plan is not approval of Trinity. It's not a clean slate principle there. Deepest of respect, it's a wrong application of law. Lordship will set aside
Those observations, those findings will set aside and send it to the arbitrator.
Correct.
Please,
I agree.
my lord, those observations, my lord, I have kindly appreciate what my defense is once, and then if your lordships want to.
You think you can sustain those? You can support those observations?
No, my lord, I have because your lordships have not been told what my defense is before the tribunal.
Forget about the defense.
Yes, please, my lord.
What the learned judge has said, that because of approval of the resolution plan, yes,
May I just
the
take one?
debtors' claims go.
My lord, may I just take 1 minute if your lordships hear me, and then your lordship will pass whatever
This
directions.
is, Millard, we can do, Millard. Lordship is
Your
not
lordship will-
giving me any protection, but
your
this
lordship
is going to hit me.
Yes,
It's
my
my
lord,
fault.
may I just, no,
Para
my lord, an
29.
order in section 9 will not prejudice the tribunal. Your lordship may provide that. No issue is finally decided at the section 9 stage, even
29, Lordship has to be like expunged. 29. 31. No, 29. Bhulbal bolo na. 29.
tribunal will not be, tribunal will
27 and
decide
29.
uninfluenced by this.
Millard, it's my appeal. He doesn't have a cross objection. Lordship considers 27 and 29. He doesn't have a cross objection today. এর আগে আমি কেটির সঙ্গে চলতে চাই না।
It was a resolution plan in respect of the petitioner.
29, Millard, cannot be. It cannot prevail.
Petitioner's claim as that of financial creditor. That is what. Correct.
আমি তো মেন ম্যাটার অ্যাপিল করছি। আমি তো অর্ডার চাইছি।
Yes, what do you want to say, Mr. Thakkar?
My lord, I only want to say this. My defense, which is the substantive defense which was before the section 9 court as well as before the learned arbitrator, is this, that this so-called loan transaction was in fact not a loan transaction. I am an entity which is controlled by, your lordship will see, the appellant before your lordship is SREI Equipment Finance Limited, which is an entity which is controlled by SREI Infrastructure Finance
You are
Limited.
going into the merits of the case, Mr.
No, my
Thakkar.
lord, why these observations are there? They may be correct in law, incorrect in law, but the court has
You tell us, it can be correct in law.
my lord, there is what has perhaps weighed with the learned court and which the court has not expressed a final opinion. The section 9 findings, observations are not final. They are like the interim orders which your lordships also pass, which are always subject to the trial of the suit.
The petitioner's claim as that of a financial creditor
Yes.
ought to have been included in the plan.
My lord, in the plan of SIFL, because these monies were advanced on the instructions of SIFL.
আমার নষ্ট করে লাভ নেই।
The lordships will,
bow
my lord,
down,
the
set aside 27 and 29. Millard, I go back. I am.
this so-called loan was advanced at the
My
intents
appeal is
of
for the full security, not against the finding. It's a via media which will I'm agreeing to.
ওই observation গুলো
I bow down, Millard.
পাঠিয়ে দেব।
And my lord, 24 last 3 lines, lordship sees para 20. My junior is correct. Yes. Lordship takes, I leave it to your lordship, my lord, whatever way.
As we said, those observations in 27 and
My lord,
29.
these, my lord- Yes, he says so, my lord, lordship, I am, my lord, because my claim, that's, my lord, my main thing. My claim gets extinguished. I could have understood it's a clean slate principle, my lord. It's, my lord, Srey's, some, my lord, someone who has borrowed money from Srey, my lord, he is coming, my lord, that is not included there, my lord. It's a reverse
Issue.
scenario.
Issue.
Grateful, my lord.
This appeal is directed against a judgment and order dated June 18, 2025, whereby a learned single judge of our court disposed of APCOM 1049 of 2024, being an application under Section 9 of the Arbitration and Conciliation Act, 1996, filed by the appellant herein. Stop. Paragraph. The short and relevant facts of the case, short facts of the case, relevant for the present purpose, are that there appears to have been a financial transaction between the appellant and the respondent. Stop. The appellant claims that a huge sum of money in the region of rupees 53 crore.
53 crores, 61,000.
In the region of rupees 53 crore.
crores, 61 lakhs, 39,447.
53.61 crore. 53.61 crore is due and payable by the respondent to the appellant. Stop. To secure such claim, the appellant approached the learned single judge with its application under Section 9 of the 1996 Act. Stop. Initially, what order was passed?
Well, initially an order
Where
was
is that?
passed. The initial order is 293 of your lordship.
Thou.
Brief. That is 19th of December 2024, volume 2.
Where is it? Internal. Initially, an order dated December 19, 2024 was passed by the learned judge, which reads as follows. The operative portion of which reads as follows. বুঝেছো? বুঝে নাও। এইটার মেমোতে যে impugned order এর পেজ 2 তে কোট করা আছে অলরেডি। সেই কোট করা পোরশনটা। Internal page 2. হ্যাঁ, impugned order টা মেমোতে অ্যানেক্স করা আছে। পেজ 2 এ ব্র্যাকেট করে দিয়েছি 2 and 3.
Only bit of on merits.
Next. You used an affidavit before the learned judge.
Yes, I took out a vacating application.
Oh, I see.
That was treated as an
And this impugned order disposed of both the
Yes,
applications.
please, ma'am.
It was a without contest.
Paragraph. The respondent filed an application for vacating the interim order referred to above. Stop. The appellant's application and the respondent's application were heard together and were disposed of by the judgment and order sought to be assailed in this appeal. Paragraph. After hearing the parties, the learned judge reduced the quantum of security that had been ordered in favor of the appellant herein. Stop. The relevant portion of the learned judge's order reads as follows. বুঝেছো? এবারে impugned order page 22 থেকে খালি 32 paragraph 32 or 33. বুঝেছো? 22
এত দেবে না, আমি বলতে পারবো না।
হ্যাঁ, paragraph 32 and 33.
RCL manages both petitioner and SIF.
Paragraph. Being aggrieved, the petitioner before the learned single judge is before us by way of this appeal. Paragraph. We are told that the arbitration reference has not only started but is at an advanced stage.
Examination is complete.
Stop. Examination of witnesses is complete. Stop. Therefore, we are not inclined to delve into the merits of this appeal. Stop. However, we find that certain observations are made in paragraphs 27 and 29 of the
And
impugned order.
also, my lord, 24 at page 13.
What is wrong there?
There is thus in my prima facie view, petitioners claim that the amount of such and such payable is not supported by any admission.
No, this is on the appreciation of evidence with the
Very
greatest
well.
of respect.
I say, my lord,
This is yeah,
No,
this
it's not.
just one, my lord. I leave it to my lord. Last, my lord. And my lord, page 23, if your lordship takes, my lord, paragraph 32, my lord, last 3 lines. Because I don't have a control to 397, 241, 242 is pending.
Which
last audited accounts of the
No,
respondent shall
page
be
23, last page of the order, lordship takes.
page 20,
Internal 23, internal
23.
page 23 of the order, my lord,
Yes.
before your lordship.
The petitioner is always at liberty.
No. The order of injunction is vacated. In my view of the discussion on finding, NARCL, which manages both the petitioner and SIFL, has sufficient control in the respondent
this is
company.
the fine. This is the
We are
fine.
fighting before the NCLT on control of the company. These are the 3 wrong findings, Millard. That's all, Millard.
No, this is a
That is a view of the learned judge, Mr.
I
Ghosh.
leave
We
it
are
to you,
not.
Lord. I leave
Yes.
it to you.
কি বললাম? Paragraph 27 and
বলি আমার কথা বলো।
which দিয়ে দেবো, quote করে দেবো? Which read as follows. এখানে quote
That's
করে
all.
দাও। 27 and 29 paragraph. 27 page 15 আর 29 page 19. ঠিক আছে? Stop. Paragraph. The obvious error in the aforesaid paragraphs is that the resolution plan in question was of the appellant herein. Stop. The same could not have included the dues owed to the appellant company by third parties. Stop. Therefore, the question of the appellant's claim against third parties being washed out by reason of the resolution plan being approved, does not arise. Stop. We clarify this, and therefore stop. The observations to that effect in the aforesaid paragraphs are set aside.
Grateful.
Paragraph. The parties will be at liberty to pray for further orders before the learned arbitral tribunal. Stop. Paragraph. The appeal and the connected application are disposed of.
বলে দিয়েছে তো, this is set aside. It's set
But the-
aside.
But one line, if your lordships are pleased to add,
Yes.
the tribunal will decide the matter uninfluenced by.
Yes, of course.
ওই চেয়ে নিয়ে।
Paragraph. We clarify that since we have not addressed the merits of the case, the learned tribunal is we clarify that since Kerala, we have not addressed the merits of the case. This is Justice Banerjee, na?
Yes.
সাবধানে লিখো, ভুলভাল না হয়। Stop. The learned tribunal is requested to decide the disputes between the parties without being influenced by
Millard,
Because
he was on the firing line, Millard.
some line of
So
my
much-
defense will be affected, my lord.
without
So
being
anyway,
influenced by any observation in this order.
please, my lord.
All right.
That he was on the
Grateful.
firing line, Millard, at the crossing.
Now that your lordships have
It's over,
vacated the
Millard.
order, my lord,
I was laughing.
It's not the resolution plan of the appellant. It's the resolution plan of Shrey Infrastructure Finance.
But that is not what
That is
appears.
what it was.
That's what is written, my lord.
No, no.
That is what is
there,
written.
That is there.
That is what is written. I
That
did
is-
not trouble your lordship, my lord. The
That's-
petitioner was included.
It's a
May I just
consolidated
read it out,
plan.
my lord? And your lordships, I'm not seeking any modification. Kindly bear with me for half a second because your lordships are holding. The petitioner was included in the committee of creditors, that is of the parent company SIFL. But being a related party to SIFL, that is the common parent of both these entities, was not allowed to represent, participate, or vote in the meeting of committee of creditors. So my contention was this was a money which ought to have been recovered from SIFL, not from me. And that is what the learned judge has held, that this claim would have been made in SIFL's claim. And if this claim was made in SIFL's plan,
Not even argued. He was
this is-
not there.
I was not there, but this is my contention. So your lordships have made an order. I'm not, but this is
Allow
what
us to rise a little early today.
Yes, happy.
So therefore, happy puja.
It was on
both
the
of-
firing end, Millard.
Yeah.
In the arbitration, I was laughing. Then Millard, it turned.
grateful, man. That's
Yes,
deeply okay.
yes. Happy pujas, happy pujas.
Packet number 4. My happy puja may take one more minute or 2
Lord,
minutes.
I'm
Because-
renewing my prayer, my lord.
I'll tell you what giving the consent would, but whatever your lordship will do, it's for your lordship. I cannot give a consent. The reason being,
Don't give consent. You have told us, Mr. Bose, your NCLT hearing
yes,
has been
yes,
stayed.
that's why. That's
You
why.
don't have to give
Yes.
consent, but
I'll just
last
indicate.
day you are also appearing in this.
My lord, may I just indicate
Not before NCLT,
No.
but I'm a party.
a party? He is appearing for the.
Lord, I have requested Mr. Bennett to him to bring that online hearing.
You are appearing for?
There are money.
For one.
Ah,
Lord, happy pujas for. That's the only submission Lord, I'm making.
Lord, respond numbers 1 and 2.
Respondent numbers 1 and 2.
Lord, who's the
My-
plaintiff?
my-
Which is the plaintiff?
my lord, may I?
Mr. Valana, you are appearing for whom?
Respondent numbers 1 and 2 being the
Who are the
plaintiff.
plaintiffs?
Lord, Money Square is Milord the guarantor, and Money Realty is the borrower.
Mr. Bose, we'll take it up immediately
Yes, yes.
after.
Please.
Then why?
I know you will. I just that's why you must also know why. I mean, on the last day, I didn't want to come also. I came just for this, and I was not in the trial court.
When I was,
My senior
was-
has gone to London. So I've been
your senior
there.
your
Mr.
leader-
Sudipto Sarkar.
leader in this matter.
Yes,
Right.
he was
All
there.
the more reason.
I was not there in the trial court also. So let me just indicate to you why, what is the matter about, and then you will, of course, do the needful. There are other ways you can protect both sides. You'd say,
The matter is on 16th, my lord. My lord, that can be
no,
deferred.
8th. Oh, so Baba. On 8th, I have spoken to the advocate. Please calm down.
8th
Huh?
of
8th of October for admission against the guarantors, 95 personal guarantors. That is Mr. Mukherjee's
one of
client, Sanjay Jhunjhunwala, and whoever is there. And
Plaintiff.
16th is against
Plaintiff.
the main borrower, against the for admission. Now, what has happened here, Millard? I filed the normal admission proceedings.
As in order. Nothing is reply.
Millard, there are two ways.
you are the applicant before the NCLT.
No, my lord,
I am. Millard, my loan recovery notice has been stayed. And therefore, indirectly, the NCLT proceedings, the debt which is due by recalling the notice, 4 notices have been stayed. So basically, the NCLT proceedings is he's been washed out, which is a prior proceeding. That is neither here. Well, Lord, that is the subject matter. I will, whatever it is. So you can direct whatever. I can't request the NCLT to adjourn the proceeding on such and such date. But if your lordship is there, that's what I mean. I've spoken. If I say influence would be uninfluenced, that would be absolutely basically create more problem. Millard, I can say that NCLT will be uninfluenced by the order. But whether your lordship, that's the first thing. But I don't know. That is what also learned single judge said.
The problem we understand, as my brother explains to me, is that your recall or demand notice has been stayed.
Yes,
So
and
today,
yet learned judge says that, but this order will not affect the NCLT proceedings.
no. So
And
today
when-
NCLT may dismiss your application.
Yes, will not
will-
admit.
Will not admit.
No,
We will ask NCLT to stay its hands till we decide this appeal.
that is, I am not saying that is your lordship is.
That should serve your purpose also. Issue. Accommodation is
Please.
next step on NCLT. Till states and still we decide this appeal. Decide NCLT matter to শুনবে না।
I am not saying.
তাতে কি হবে না?
My lord, my lord, I have not elected.
We will do that.
May I? Please do not take me amiss. You see, I have not asking for stay of NCLT proceedings. My contention before said that you cannot stop NCLT proceedings. My lord, this is the thing. So let it not be construed that
Nothing will be construed, Mr. Bose. We are not even using the word stay. We will just say NCLT shall defer hearing of this, whatever you have filed, till we decide this appeal.
My lord, it's fallen from your lordship, my lord.
Yes.
And
Why are you so worried? It's falling from us.
Because my lord, the clients are from, and now they listen to all YouTube and all this.
Accommodation is no, it's the court's order because today is the last day. We don't have the
My
time.
lord, please say that, because you see, my prayer is, my lord, that let it not be construed that the NCLT, your lordship, by this order has stayed the NCLT proceedings. My lord, your lordship understands the
Your lordships
predicament.
are not even, my lord, your lordships are not
Yes,
even
yes.
empowered to do it. Your lordships couch the language.
Correct.
My lord, whatever way your lordship,
On
my
that
lord,
date, it happens after your
my
lordship.
lord, it is on their prayer that this time, my lord, lordship do.
The
As item we have not been served, they filed a fresh appeal.
This appeal is directed against a judgment and order dated August 12, 2025. No, sorry, August 19, 2025, whereby a learned judge of this court whereby na
Para 45.
45 years. A learned judge of this court. কি বললাম? This na 25, passed on an application made by the respondent numbers 1 and 2 herein in its suit being CS.Com number 93 of 2025. Stop.
My lord, in para 45, the learned judge has, my lord, in para 45, learned judge has held that
We are seeing that, Mr.
Yes.
Please allow us to dictate.
44,
Stop.
44, my demand notices have been.
Operative portion
Yes.
of the said order reads as follows. Internal page 25, impugned order করে para 45 টা set out করে দাও. Para 45. Paragraph. In effect, what the effect of the aforesaid order is that the notices issued by the appellant herein recalling
Recalling the entire and
the
making
entire
claim.
loan have been stayed. Stop. Being aggrieved, the appellant who you were the respondent number before the learned judge.
1 and 2. 1.
Being aggrieved, the respondent numbers 1 and 2 before the learned single judge have come up by way of this appeal. Paragraph. Accommodation is prayed for on behalf of the respondent numbers 1 and 2 in this appeal. Stop. This is opposed by learned senior counsel appearing for the appellant.
Well, because the effect would be stay of the
appellants. Stop. Learned senior counsel expresses his concern that because of the impugned order staying, the demand/recall notices, the appellant's application before the NCL National Company Law Tribunal would be rendered infructuous.
Applications.
Karo. Stop. The said applications would not be admitted. Stop. Paragraph. Today is the last day before the puja vacation. Stop. There isn't sufficient time to hear out this matter at length. Stop. However, certain issues are involved, and hearing of this matter is likely to take some time. Paragraph. List this matter immediately after the summer puja vacation. Stop. Till we decide the issues involved in this appeal, the National Company Law Tribunal should defer consideration of the appellants applications that have been filed before it.
Well, section 7 and 95.
Applications under section 7 and 95 of the IBC, Insolvency and Bankruptcy Code. Yes.
Now I can wish.
Joy Guru.
Grateful, Manoj.
Thank you, and same to you all.
Item 7.
Is he in Paris? Where is he? Is he in Paris?
I don't know.
I wish, Manoj, I wish I was, Manoj.
I think he's on way, Milord.
Oh, Milord. Item 7 is connected matter.
We have not been served.
We have filed just a memorandum, Milord, because on the returnable day, the interim order was extended. So
4 and 7 একসঙ্গে দিয়ে দিও। না 4 and 7 এ কোনো অর্ডার হচ্ছে না। হ্যাঁ, একজন করে পরপর দিয়ে দেবে।
Milord, notice dispense with formalities and every prayer day, basically.
In 7?
No, in
আচ্ছা 4 যেটা হলো প্রথমে লেখো without certified copy that prayer
তাই তো
আচ্ছা তো
there will be an এই stay petitionটা দাও তো একবার।
আমি দেখলাম না তো
না
একটু ভুল আছে, একটু ভুল থাকবে বলছি।
ভুল আছে। দেখিনি two mistakes, my lord, which
Yes, without certified copy.
undertaking গুলো
There will be an order প্রথম একদম গোড়ায় there will be an order in terms of prayer A of the
invitation of undertaking
তারপরে যা বলছি।
My lord, the undertakings are not proper. It should be dismissed, my lord, on that ground.
You're right. The III, the third one is not there.
List of dates is not there.
Prepare a list of dates, including
Limitations.
Mr. Thakkar, do the needful. Yes.
That your lordship can direct.
Kindly
can do that. We can do that.
Milord, some
Sale add করে দাও।
Milord, some
Add করে
papers, Milord, in the Xerox have been missed, Milord. We'll come back with
Xerox?
Xerox এ
তাহলে
paper কিছু
ওটা add করে দাও।
লাস্ট পাতাটাই মিসিং
Listing-
আছে আমার
লিস্টিং এর আগে
হ্যাঁ না
চারে
email টাও check
চারটাই
করেছি,
হচ্ছে।
তাতেও নাই। আরে আমি বলে দিচ্ছি আবার
Learned advocates for the parties agree that the appeal may be heard out. Stop. Let requisite number of informal paper books be filed by the appellants containing all papers that were available before the learned single judge, comma, within
Stay application has all the papers subject to corrections. It was missed out according to them.
then we will treat the stay as the informal paper book.
Yes.
তাহলে এভাবেই লেখো। Let informal ওখান থেকে কেটে দাও। Let requisite number থেকে কেটে দাও। দেখো, learned advocates, learned senior counsel for the appellants tells us that all papers that were available before the learned single judge have been filed with the stay application. Stop. We shall treat the stay application as an informal paper book. Stop. All formalities are dispensed with. Stop. Notice of appeal is deemed to be waived since all the respondents are represented. Stop. Paragraph. The appellants shall file an index of the papers. Stop. Our paragraph learned advocate for the respondent numbers 1 and 2 says that all papers are not there or are not annexed. That's what you said.
pages are missing, Milord. The petition is annexed. but
Says that
pages-
some pages are missing in the stay petition. Stop. The respondent numbers 1 and 2 will be at liberty to file a supplementary paper book incorporating such pages. Stop. Paragraph. If I list the matter, then give us a date when we'll hear the appeal.
On the reopening, your lordship is fixing.
After reopening is no, not on the reopening day.
Oh, after reopening.
You want to do it on 24th of October?
I am there because I'll be returning by that time. So it's entirely convenience. Whenever your lordship, but fix a date.
You'll be following your senior.
No, I'm not there. Somewhere else. Senior will come back and again go in on 28th October.
Yes.
Well, at one place.
You decide, discuss and give us a
Monday
date.
and Friday लेते हैं ना?
Milord, your lordship's taken Monday, Friday, Milord.
Monday, Friday.
So, Milord, either 27th or 31st, Milord, whichever.
27th.
कौन सी list होगी?
27th, 31st, whatever. 27th.
27th.
27th. This is the matter, 27th. Huh?
ও কি করছে ওখানে?
In 7, there should be an order. Prayer also.
No application for it.
Oh, no application is there. Very well. Let 7 be listed immediately after 4. ঠিক আছে? ওখানে লিখে দাও, লিখে দাও।
Milord, that order can be passed in both 4 and 7.
ও together.
Yes.
তাহলে এই অর্ডারটা তুমি একসঙ্গে করে দাও 4 আর 7 এ। মুশকিল হবে কারণ then we have to refer to the other. No. Let 7 be. Let APOT 282 of 2025 be listed immediately after this matter.
আর time কখনো ঠিক
Milord, when the index is being prepared, Milord, I'd request a bookmarked copy, Milord, for us.
Well, even I am also requesting.
Taking is a e-mark of bookmark, I don't think. We will provide it to Mr.
আমাদেরকে দেবে না।
All right, thank you.
Whoever will ask, we will provide.
Deep level.
Very
করতে যখন হয়ে যাবে।
Daku 5.
It should be prepared by us.
Item 5 and 6.
Item number 5 and 6. I appear for the appellant, my lord. I'm being led by Mr. Rachit Lakhmani, appearing virtually.
Lord, I'm sorry to not be there physically today. My lord, items 5 and 6 are appeals from the same impugned order. My lord, before placing the impugned order, may I, my lord, just in a nutshell tell your lordship the relief, my lord, that I'm seeking today. My lord, I am a defendant in a money suit, and my lord, the principal claim against me is 94 lakhs on account of alleged loan advanced on an oral loan agreement between, my lord, two friendly parties. Now, my lord, in this case, an injunction order has been passed upon exchange of affidavits, restraining me from operating my bank account without keeping aside a sum of rupees 94 lakhs. Now, the partnership firm is comprising two partners, husband and wife. Wife is a housewife, and the husband has had a paralysis stroke. Now, the business is being run by a young son, 24 years old, who's abandoned his education for the time being to look after the business. All I'm saying today, is allow me to secure this money by way of an immovable property, which I undertake not to alienate, which has been valued at 1.02 crores by a registered valuer. The principal claim against me is 94 lakhs. And kindly allow me to operate my bank accounts, because there are payments to be met. The businesses of railway contracts, there are several truck drivers who are to be paid, transportation companies. This order will have a multiplying effect and make me a prolific debtor all across. So kindly consider, I will not alienate a particular immovable property. This is my case.
Bobby,
I appear for the, sorry.
2/9/2025. Order to that, 35.
But I appear for the plaintiff, the respondent here. Firstly, I am 31st July order. They are moving it today. And secondly, I have a point of maintainability whether this appeal could be maintainable at all, because this is a modification order, which is not provided. It's not an appealable order under Order 43.
Mr. Lakhmani.
Yes, my lord.
Sorry, not today. Not today, because 31st July, your client's sense of urgency is demonstrated by the fact that the appeal was presented only on the 2nd of September. So if he could wait for that long, come back on the reopening day, we'll see. We'll consider. And you take instruction, Mr. Dashgupta. Mr. Dashgupta, that if your claim is sufficiently secured, you want security.
Yes.
Why stop a business?
No, I do not intend to.
Yes.
They proposed an immovable property which they say is valued in excess of 1 crore, but it is not borne out from the records.
No, so therefore, Mr. Lakhmani, why don't you convince Mr. Dashgupta or his client that the property that you say is valued at rupees 1.02 crore is indeed valued at that sum of money?
No, they are deriving sadistic pleasure from this litigation. I'm sorry to say so. It's very difficult to
We
convince
also,
Mr.
we also
Dashgupta's
have
client.
nothing before us to show that this property is worth 1.02 crore.
My lord, there are
No, I have placed documents on record, my lord. It's a building in Jaipur, in urban Jaipur, where each floor has about 400 square feet. And it's a basement plus ground plus 4-story building. The construction price alone is 2,700 rupees per square feet. My lord, how are they saying, my lord, that this would not secure? It's a basement plus ground plus 4-story building built, my lord, on a plot about 500 square feet, where each floor is 400 square feet.
You supply the particulars to the plaintiff. Let them satisfy themselves. On the reopening day, we'll pass the order. We'll substitute.
Your lordship may, my lord, kindly consider, my lord, recording that this relief that I'm seeking would be considered on the reopening day.
Yes, yes.
I'm so grateful.
The reopening day, maybe on the 27th.
27th, the following Monday. Reopening day is
unrealistic. That's the de facto reopening day.
Mr. Lakhmani will also not be there. I'm quite sure about it.
Sure.
He'll be
The
somewhere.
27th, I'll be there.
He'll somewhere in Croatia. Or
27th, I'm there.
This appeal is directed against an order dated July 31, 2025, passed by a learned judge of our court in... How many suits are there?
2 suits. 2 suits, that's why 2
one
separate
is 75 lakhs and one is 20 lakhs. Both.
74 lakhs is the claim in one suit, and in the other, it's 20 lakhs.
In 2 suits instituted by the respondent herein against the appellants. Stop. By the order impugned, an earlier order dated June 19, 2025 has been modified to the extent that the defendants, being the appellants herein, have been allowed to operate their bank accounts subject to keeping aside an amount of rupees 94 lakh till further orders. Stop. This is the amount of claim of the plaintiff in the suit.
Principal.
This is the amount of principal claim of the plaintiff in the suit. Stop. Paragraph. Mr. Lakmani, learned counsel appearing for the appellant says that the order impugned is creating huge difficulty for the business. Stop. The appellants are prepared to furnish alternative security in the form of real property in Jaipur, Rajasthan. You have disclosed papers.
Yes, my lord. In the supplementary affidavit, as fallen from
Stop.
learned, we have supplemented this.
With the supplementary affidavit filed by the appellants before the learned single judge,
Learned single judge, my lord.
before the learned single judge, particulars of such property have been disclosed. Stop. The property is worth at least rupees 1.02 crore. Stop. Therefore, that will be sufficient security for the plaintiff's claim in the suit. Paragraph. We request learned counsel, Mr. Dashgupta, learned counsel for the plaintiff to obtain appropriate instruction in that regard. Stop. We should think that the plaintiff should not object to the appellant's essay for apostrophe proposal if the plaintiff's claim is sufficiently protected. Paragraph. List this matter once again on October 27, 2026.
2025, my lord.
Yes.
Grateful.
Grateful, my lord. Much obliged.
5 and 6 ki korbo?
5 and 6 both
Both
together.
are same.
Both are same matters, my
Now
lord.
the amount would be changed.
One is 74
lakhs
lakhs and one is 20 lakhs.
There are separate appeals, na?
Separate.
Separate. Much obliged.
এটাতে 20 lakh হবে। দেখি ওইটা দেখি। Just the amount is changed. Just the
Just the amount is changed.
Just the amount.
94 lakh যেটা ছিল ওটাতে 20 lakh হবে খালি।
But 94 lakh is the consolidated claim, principal claim in both the suits. One is 74,
Oh,
one is
74
20.
and
But the
The
order
strong
is
cover is
consolidated order,
74
but fast
and
separate.
Kamlesh Mohta is 20
but
lakhs.
না কিন্তু অর্ডারটা দিয়েছে 94
Yes, but the order is a combined order.
Order is a combined order.
তাহলে একসঙ্গেই করে দাও। Then combined order.
Much obliged, my lord.
Grateful.
ওই যেখানে প্রিন্সিপাল ক্লেম that amount is the principal claim না বলে একটা সেন্টেন্স আছে দেখবে ওখানটা তাহলে বলে দাও the plaintiff's claim on account of principal sum is rupees 74 lakh in which one?
In Strong Tower, private
the
limited
first-
versus Karnani
Item number 5.
Item number 5.
In CSCOM 649 of
Correct.
2024 and rupees 20 lakh in
CS
CSCOM 650
of
of
2020.
2024 ওইটা খালি চেঞ্জ করে দাও কম্বাইন করে দাও
Much
Grateful.
obliged.
Grateful.
হয়ে গেল বাজারে ও কেন এটা কি
This matter is appearing at my instance, my lord. In this matter, the appellant was directed to furnish a bank guarantee for obtaining stay of the impugned award. The bank guarantee was filed. It expired on 23rd September. The extension, although it was made within time, but it came from Delhi and could not be submitted, my lord. I am only praying for leave to file the extension of bank.
I do not have any objection.
yes yes
My lord, only one prayer I have, my lord.
দাও ফাইলটা দাও
My lord, only one prayer, my lord. After vacation, if your lordship can just fix a particular date when this matter can.
any Sunday tell us which suits you we can't fix every matter madam
হ্যাঁ, দিয়ে দিচ্ছি।
এই কিছুই তো নেই 5 crore
Yes, but with 7% increase every year. So the amount has now become 5%.
এসো
May I pray for one indulgence since this is the last day? May the leave be given in the back sheet of the original bank guarantee so I can directly file it in the department. Otherwise, I would need.
না হলে দেবে না ফাইল করতে দেবে না করে দিও ব্যাকশিটে লিখে দিও আমরা একটা অর্ডার লিখে দিচ্ছি
Sure.
learned advocate for the appellant says that the bank guarantee that was furnished by his client as a precondition for stay of operation of the award, impugned arbitral award, comma, has been renewed within time but could not be filed since the same has reached him only yesterday from Delhi.
24th.
Reached him on
4th.
Today is reached him day before yesterday from Delhi. Stop. He seeks leave to file the bank guarantee in the department. Paragraph. Learned advocate for the respondent in her usual fairness does not raise any objection. Paragraph. Leave is granted to the appellant to file the renewed bank guarantee before in the department. Now where? In the department?
Registrar, original site.
Oh, with the registrar, comma, original site, comma, Calcutta High Court.
Well, only
Comma, in course of the day.
yes. Well, only it's an extension of bank guarantee instead of the bank guarantee.
Renewed bank guarantee, we said.
Renewed.
Renewed stop extended. Renewed stroke extended bank guarantee.
I'm obliged.
Paragraph lists the appeal 1 week after the summer vacation. Acha, puja vacation, ठीक है, puja vacation, fairly at the top.
I'm so grateful, Your Lordship.
I'm obliged.
Commercial or non-commercial?
Non-commercial item number what?
I am
আপনার কোনো উকিল বাবু নেই?
person. Restored application I have filed this.
হ্যাঁ, কিছুই বুঝতে পারলাম না আমি। দিচ্ছি।
আমি অ্যাডভোকেটের সাথে কথা বলেছি, এটা রেস্টোর হয়ে গেলেই আমি একটা অ্যাপ্রোপ্রিয়েট ফর অর্ডারের ক্যান অ্যাপ্লিকেশন ফাইল করব, তখন আমি অ্যাডভোকেট নিয়ে নেব। এটা শুধু রেস্টোর অ্যাপ্লিকেশন ম্যাডাম, প্লিজ রেস্টোর রেস্টোরেশন অ্যাপ্লিকেশন। এটা ডিসমিস ফর ডিফল্ট হয়েছিল,
সার্ভিস করা উচিত।
আমি অ্যাডভোকেট নিয়ে নেব, কথা বলেছি আমি।
Dismiss for default.
টু হ্যাঁ ওয়ান ফাইল হয়ে গেছে।
তার কারণটা
Please,
হচ্ছে
my lord, আমি খুব অসুস্থ।
আপনাকে একটা দেখুন আমাদের আমাদের সহানুভূতি আপনার সঙ্গে থাকতে পারে, কিন্তু কিছু তো নিয়ম মেনে চলতে হবে আমাদেরও। আপনি একটা অ্যাফিডেভিট অফ সার্ভিস ফাইল করুন, তাতে বলুন যে আপনি সার্ভিস করেছেন এই 2 থেকে 6। আপনি ওই কাগজ দেখালে হবে না।
হয় না, শুধু আগে স্টেট কে করেছিলাম, এটা তো আদার সাইড কে আমি করিনি।
কেন 2 থেকে 6 কে করেননি কেন?
Memorandum appeal. Then I decide when I file appropriate order can application, all of the respondent কে সার্ভিস করব। এটা only memorandum appeal pending. Only memorandum appeal pending, my lord. রেজিস্টার অ্যাপ্লিকেশনটাই তো সার্ভিস করেছি, স্টেট কে করেছি। না না না, ওদের তো আগেও করিনি মাই লর্ড। আদার সাইড কে তো আপনি বলেছিলেন স্টেট কে করলেই হবে আগে যখন এসেছিল। আমি মেমোরেন্ডাম আপিলটার সময় আদার সাইড কে করিনি, ওরা জানেই না এই ম্যাটারটা। ওই অ্যাপ্রুভিং যে অর্ডার করে দেবো ম্যাটার, আমি করে দেবো সবাইকে প্লিজ। আমি খুব অসুস্থ, 67 ইয়ার্স ওল্ড। ডেট দেওয়া হোক, আমি 7th সব করে দেবো আফটার পূজা ভ্যাকেশন। 7th আমি সব সার্ভিস করে দেবো, 8th এটা রাখা হোক। 8th or 9th। আচ্ছা ঠিক আছে। নভেম্বর না মাই লর্ড, অনেক দেরি হয়ে যাবে। আই এম সাফারিং। 27 অক্টোবর। 27 অক্টোবর। হ্যাঁ হ্যাঁ, আমাকে জাস্ট সার্ভিসটা করতে হবে।
সেকশন 5টা আর রেস্টোরেশনটা,
এই দুটো আমি আদার সাইডকে সার্ভিস করে দিচ্ছি। থ্যাংক ইউ।
Item 2.
My lord, item number 2, I appear for the respondent in this matter, lordship. I'm appearing virtually, my lord.
Ms. Chatterjee.
My lord, submissions were concluded. Today is fixed for filing the written notes.
Written note.
I'm led by Mr. Siddhartha and she's appearing.
Yes, we remember. Yes, written note.
Yes.
Are you filing written note, Mr. Banerjee? Mr. Banerjee, are you filing written note today?
Yes. Milord, there was a written note filed. Milord, we have slightly modified it. Milord, may we take back, Milord, the previous written note? This is a comprehensive one. May Milord file this.
Don't take back. Don't take back because we have marked it.
Oh, very well, Milord. But this is also, Milord, comprehensive, includes, Milord, everything that was there. Milord, kindly keep this also. Kindly allow us, Milord, to file this comprehensive.
Written notes of argument filed on behalf of the respondent be kept with the records. Paragraph, the appellant.
I'm the appellant, my lord.
Oh, sorry.
Yes,
On behalf of the appellant. Paragraph, the respondent has filed a corrected written notes of argument, which learned counsel says is more comprehensive. Stop. Let that be taken on record as well.
So great.
Lists the matter once again. On November 4. November 6. Under the heading for further hearing. If we have any clarificatory questions, we'll
My lord, if I may just, my lord, I have already said it, but during the course of filing, making the fresh notes, my lord, I came across something which, my lord, I had actually not argued before. In section 19, my lord, interestingly, this deposit that has to be made of 75%, it is only in respect of an appellant who is a buyer. So, my lord, when a supplier is aggrieved by an award, my lord, there is no requirement of a deposit. But if a buyer is aggrieved, my lord, that in fact, my lord, clarifies the position that why the MSME Act has made it compulsory that when a buyer is being aggrieved with filing a Section 34, has to deposit
Now,
that.
if you are taking that point and if you have not argued it,
Included it in my notes.
no, then Mr. Banerjee should be in all fairness.
Milord, we'll exchange it. Milord,
Next
if
we will come
necessary,
back.
Milord, on the returnable date, kindly allow us 2 minutes time each. Milord,
Yes,
we'll
yes.
clarify.
Very well, very well.
Great.
Nice
my
to
lord.
Very well. Happy
Thank you,
Puja.
Lord. It's a happy
Yes.
vacation.
Grateful to your lordship. Great.
Item 3, LNP Lordship beg to approve the respondent's submission. Speaks for correction.
Correction. You put in? Oh, what হবে না?
It has been mentioned in ERB award.
Just FMAT.
Just only.
Hmm. Be corrected by deleting the expression এবার within quote দাও একবারে ব্লকে দাও আর বা word block capital from the order wherever that expression appears যেখানে আছে দেখে নিও বহু জায়গায় আছে paragraph let this correction be incorporated in the order dated September 12th. Happy Puja. ডাকো কি রে বাবা
Number 1.
May it please, my lords.
of course defective. What is the defect? কোথায় লেখা থাকে There are several defects, sir. You have to remove the defects first.
I will.
One of them is deficit court fee of 49,500. You have paid only 500 rupees. Look at the defects noted by the stamp reporter. দেখা ওনাকে. Come back after vacation after curing the defects.
Which is why I was prepared, my lords. The only submission I should make was happy push. But
no,
2 minutes.
Yes, we appreciate your gesture, but your advocate on record will have to remove these defects. cure these defects. Valuation has not been furnished. So we will list it on the 20, এটা কি commercial?
My lord,
Yes.
I
We'll
think
list it on
which
the
is
20.
not fair. The only, I'll brief the crux of the matter, that is, why this? I saw an exemption from the court fees in the appeal, and I'll tell you why. Because the court below dismissed my suit after paying the full court fee there, 50,000 rupees, at the outset when I was moving the interim injunction. Order 39, Rule 1.
Yes.
Now, what happens, my lord? Neither once the suit was rejected completely, that 50,000 rupees was already, it was not ordered for any return. Number two, my lord. So what happens? I will leave it up to my lord. If my lord instructs me to pay the remaining court fee,
You
but
will
I
have
will be in a problem, my lord.
No, Mr. Counsel, I don't think we even have the power to do as you are asking us to do. Look up the law. If you can find any law which says that at our discretion, we may consider waiving your court fees because you have paid the full court fees for the suit, which was dismissed at the
No,
interim.
that is not my submission. There isn't any law to that.
We can't. You have to pay. Sorry. If you want
No,
to
but I
press
can
the
seek an
appeal,
exemption for the discretion for the time being.
where do we have the discretion? Show us.
My lord, be pleased to.
Yes, I mean, you have to show you're indigent, correct? You do
No,
the needful,
I
come
will
back.
do the needful.
Do
My
the
lord, be pleased to keep it within the first week after reopening. I will
27th.
20 much obliged, my lord.
Sorry, 28th. 27th is Shombar. 28th is a Tuesday.
Much obliged, my lords.
Several defects have been noted by the stamp. Several defects in this appeal have been noted by the stamp reporter. Paragraph lists this matter once again on October 28, 2025. Stop. In the meantime, learned advocate on record for the appellant will be at liberty to cure the defects. Thank you.
Much obliged, my lords, and very happy Puja vacation.
Happy Puja.
In fact, there was something which I was specially instructed by a learned friend, and he specifically says from Delhi that the Truff Club was introduced to him by my lord. I don't know whether my lords remember him. His name is Mr. Suresh Grover. He happens to be the managing director of a company called Slipco Constructions.
I see. I think so. Yes.
So he conveys his regards personally.
I think I appeared in arbitration as a counsel for the company. Before Justice Anil Sen, perhaps.
Just before my lord was elevated.
Yes.
And I thought of conveying the regards on the bicentenary dinner.
Yeah.
But my lords,
Yes,
I
it didn't
couldn't.
happen. Yes.
So I took this opportunity.
Well, you also please convey my regards to him. I remember him.
I will.
I remember him.
I will. Much obliged.
Thank you.
Much obliged, ma'am.
Who's appearing for the? You were assisting Mr. Chidambaram. And Mr. Mukherjee, Gopal Mukherjee.
Banerjee is appearing online. He was assisting Mr. Mukherjee.
Oh.
And I'm for the aspirant number 1, the advocate, part of the advocate records.
It's fine.
No, I was being led by Mr. Sen and Mr.
Proceed.
Thomas.
Very well.
We have set aside the order. We have allowed the appeals.
Lordship, may I humbly pray for stay of the order, Lordship?
Likho after, later, huh? Later, likho. After judgment is pronounced in open court, comma, learned advocate for the respondent number 1 oblique plaintiff, respondent number 1 oblique plaintiff, prays for stay of operation of the order, stop. The prayer is considered and refused. We are absolutely convinced, therefore we are not staying.
May your lordships have an excellent vacation.
Yes, and you too.
Thank you.
Where?
Bali.
Oh, only Bali. Lovely. You've been to Bali before, na? Yes, I love that place. Lovely.
Great.